Since Sunday night, so we understand if he's a little bit tired, and we appreciate that, but we appreciate him taking time out to come talk to us today about something very important, and that's FOIA from the practical side. You heard from Ryan talk about FOIA from the side of custodian, from the perspective of the legal community, and particularly our office, but Chad Day is going to talk to us a little bit about how he's used FOIA and give us a case study about using FOIA and covering a story. Chad is a reporter on the investigative projects desk at the Democrat-Gazette, and he specializes in computer-assisted reporting and long-form investigations. He earned his bachelor's degree at the Missouri School of Journalism and has worked for the Kansas City Star. He was named Arkansas Young Journalist of the Year in 2011, and last year he won the Press Association's Freedom of Information Award. He and his colleague Kathy Fry have also won the I.F. Stone Award for investigative reporting and the Society of Professional Journalists Robert S. McCord Freedom of Information Award. I think his presentation is going to be really good, and here's Chad Day. Let's give him a round of applause. Thanks.
How you doing? Looks like we got a pretty good crowd here. I want to thank the AG's office for inviting me to this. And we'll be talking, like you said, about the practical side of FOIA. Basically, FOIA as a journalist. Just too loud? Just okay? All right. Basically, just to give you kind of a roadmap of what we'll be talking about, I'm going to go through some basics of FOIA from a journalist perspective, give some examples of essential open records that we use every day, and then I'll talk about an investigation that Kathy Fry and I did that relied pretty heavily on the FOIA. So why do journalists use FOIA? Basically, these various reasons. My favorite is the fishing and goose chase, particularly wild ones. I see there's some PIOs in here. So, but it's basically to have a good excuse to bring out a lot of righteous talk and use it to browbeat an underpaid, overworked public servant who is just doing their job. As we know, hopefully I'm joking, although kind of. But why we really do. The functioning of a free democratic society is built upon the idea of an informed public. You know, we are ethically bound as journalists to basically stand in for the public, observe, question, and at times that will challenge you know, government in the way that they're conducting their business. The Freedom of Information Act is essential in giving the public and the press the statutory right of access to the government, and it is the bedrock of basically everything we do, as Danny Shamir will tell you, who is my boss. One brief point I want to do before we kind of go on. The Freedom of Information Act, I'm sure people have talked about this today, it doesn't tell the government what they can withhold from the public. It just tells them, what they can withhold from the public, not what they can release. So if your request is ever denied by an agency who says the law doesn't require the information released, you should challenge them. Most of the time they're wrong, and they have to give that record to you. So it's an exemption law, it's not a permission law, as most everybody probably knows here. So on a day-to-day basis, there's reporters in the room here that can tell you that the FOIA allows us to go into city council meetings, water, transit, sewer utilities, publicly funded state agencies, police departments, county offices. It is the basis for almost all of our access to information that we report on every day, that you see in the paper, you see online, you see on television. And it's also a, you know, basically the FOIA works as a safeguard. You know, access to public meetings, the mere presence of a reporter at a meeting can hold a governmental body in check. Routine access to public records can have the same effect and basically follow along the same rule of people seem to follow the rules better when they know someone's watching them. There's some courts people, so correct me if I'm wrong here, and I'm sure there's plenty of people that will correct me. In Arkansas, public records, you know, are governed by FOIA, but in the judiciary it plays by its own rules. Oh, I guess we're getting an echo. In Arkansas, Administrative Order 19 actually governs access to court records. But it basically references and borrows a lot from FOIA. It basically says, while there are some exceptions, it affords public access to court records as well. I just wanted to point that out. Now to actually why I'm here. Sunlight is an antiseptic. In 2011 and 2012, Reporter Kathy Fry and I published a series of stories on the justice system in Phillips County. The series started with tips from sources, but over several months of our reporting, we reviewed more than 20,000 pages of public documents. Most of those were court records. Some of those were jail booking records, which I'll get into a little bit later. But without them, we wouldn't have found what we did. In October 2011, a lot of people probably know about this, but about 70 people were arrested in Helena, West Helena, as part of a federal corruption and drug sting. The FBI called it Operation Delta Blues. If there's anybody in the room, they really like their names. That's a good name. I think it's a good name. 5 police officers have since either pleaded guilty or been convicted of corruption charges as a result of that investigation, and numerous people of those 70 defendants have also pleaded guilty to various drug charges. You know, what we knew at the time, Kathy and I were assigned to cover that investigation, and what we started out knowing was that we needed to check the case records of every defendant that was indicted in the federal drug sting. So this is kind of where the Administrative Order 19 comes in. We spent weeks in the Phillips County Courthouse going through their histories, and that's when we started to see this pattern develop. Many of the men, and I say men, most of the defendants were, had racked up several years' worth of felony charges that never seemed to get resolved before they picked up another charge. And so if there's attorneys in the room, basically what we were seeing was that there would be a case started in 2002, another case started in 2003, and they were still unresolved by the time we were there in 2011, sometimes to 4 or 5 various felony cases that were very serious. Some violent, most drug-related, but some violent rapes and murders as well. We also kept finding defendants who had active fugitive warrants out for their arrests that never seemed to get served. And this was something that's kind of essential to what we found. That was the case even when they were arrested again and again. Give you an idea of basically how we kind of started to investigate this pattern. You know, we basically audited the district and circuit courts in Phillips County. This took months. We basically went through hundreds of case files and had to track when the warrants were there. And then I built a database out of that. It's pretty nerdy, but we called it a fugitive tracker, which is probably a better name, and started putting together timelines of the various fugitives. What we would do is we would look at the court records. We would say there's a warrant that's been issued on this date, and then we started tracking their arrest records in either district court, circuit court, other areas of the state. And we found they were being stopped by police. Some guys had been stopped as many as 25 times while they had an active warrant, but they were not arrested on that warrant. These were fugitive warrants, which are, you know, fair to appear, you don't come into court, but they involved cases that were very serious. And we'll get to that in a second, but they were Class Y felonies, which is the worst felony, rapes, murders, you know, drug trafficking offenses that are, you know, serious drug trafficking offenses. And so where FOIA came in big time was that we needed to see if they'd been in jail. I don't know, did you guys talk about the Hingle court decision, booking records? There's a court decision, it's Pine Bluff, basically, that allows anybody access to jail shift sheets, jail booking records, as long, you know, if it's a 24-hour facility, you can be able to walk in there at any time and see the booking records, who's in jail, what the shift sheets of the people that are working there, arrest records, that kind of thing. It's a very important decision in FOIA, and you'll find it in it's in the small booklet as well. But this is where FOIA came in. In August 2012, Kathy and I walked into the Phillips County Sheriff's Office with a 1-page FOIA request. If there's lawyers in the room, you'd probably think this was pretty ridiculous, but I tried to be a lawyer in this case. And I used a lot of scary words like felony and tampering. People like tampering, so it's very ominous. And the sheriff, who's no longer the sheriff anymore, Ronnie White, hopefully he's not here, consulted with his attorney and then agreed to let us review what we wanted, which were his booking records. There was a hitch. And this is something you'll find if you're requesting, while FOIA and various case law require that jail booking sheets be publicly available, it doesn't say where they need to be kept. And so if I don't know if you've ever been to Phillips County, but the sheriff's office is a small little building on the corner, and then the jail is behind it. And so we had to walk back to the jail, which was a very quiet, seething walk, and then he took us to the records. They were in 22 boxes, they were behind locked doors, and they were in a holding cell. And if we wanted to go through them, we had to be locked in, and so we were. We spent the next 2 weeks in that cell, not continuously, I will say, but 6 to 7 hours a day going through there. It was not locked. The inmates walked freely around us, and unfortunately, we were next to the preferred bathroom. I don't know if they picked that bathroom to intimidate, I don't know, but it's pretty nasty. Most days we were let out of jail by a trustee who had access to the door locks, which was also kind of disturbing. We were periodically checked on by a jailer, who was very nice, I will say. And yes, this jail has since been shut down because of some of the other policies that they had there. But basically, we had to go through these records by hand, and we used what were the handheld scanners, which is probably the best thing that you can buy if you're going to try to do FOIA requests for large amounts of documents. It helps you to avoid a lot of copying fees. It also helps if you're a custodian. You basically don't have to pay for all that search time. You can just open up the records, if they're public records that don't have a lot of confidential information in them, and let the requester come in and scan them, and they can scan to the heart's desire. You basically run it over the top of it, and it's a great device. It'll store about 500 pages or so, and they're about $70 if you guys want one. So what we found, we took these records and compared them, put them all into our timelines in our database, and we found that more than 400 fugitive warrants issued by circuit judges went unheeded by law enforcement over a 12-year period. Those were also the 12 years in which that sheriff was in office. In Phillips County, about a quarter of the defendants charged in Class Y felonies, which it's a county that had about 101, about 101, and so there were 24 that were in either a rape, a murder, or a large-scale drug trafficking charge. And in many cases, in total, I think, in total those defendants were released at least 60 times while they had outstanding warrants. Basically what would happen is that a warrant would be issued by a judge. He would sign off on it, and it's supposed to go to the sheriff, who's then going to enter it into a database called the ACIC. There's state police here in the room, so they know all about that. ACIC basically allows for law enforcement, when they arrest somebody, to see if they have a warrant, also to see their criminal history. In this case, none of these warrants were in there, so when police officers were stopping somebody, they didn't know who they were coming upon. They were actually coming upon a wanted subject who had various and sundry criminal record, but they had no idea that they were wanted. This becomes an officer safety issue, mostly because if you're approaching somebody who's wanted, they're probably a little bit more desperate and might actually injure you or pull some type of either escape or try to harm the officer, which was one of the main concerns that we had. More than 40% of the Class Y fugitives defendants in the county weren't arrested on their warrants when law enforcement officials had opportunities to do so. Like I said, there were some who had 25 opportunities, traffic stops. They were actually in court. They actually came to the same court that had issued the warrant, and yet they didn't have it served. The Phillips County Sheriff's Office also didn't carry out, we came across this while we were looking, actually, while we were there, we left one day, came back to the same file, and this record had been inserted in the file. And it basically had noted that this main defendant in the drug trafficking conspiracy, and I can say that now, he's been convicted, was basically supposed to be in prison the entire time that he was running the drug trafficking organization. But they had not served that. It was actually a mandate that came down from the Arkansas Court of Appeals. Instead, he remained free and went on to run the drug ring. He's now serving that state sentence in addition to his 40-year federal prison term. One thing that also came up was that, when we had gathered all this information, actually in May of 2012, we went into the sheriff's office, and I was prepared. I had all my lines of questions, ready to be like, why wasn't this happening? And instead it was just, he said, yeah, we don't do that. We don't enter those records, and we don't serve them. And so that was one of the other main findings, was that the sheriff had a policy of not entering fugitive warrants into ACIC's database. This allowed for fugitives to live freely, basically. And then also there was a time element of this that fell into the cases, basically the trial time, where it allowed for 200 cases to have to be dropped. They were actually dropped all on the same day because they were so flawed they couldn't be prosecuted. One of the main consequences, and probably the saddest thing that came out of this, was that the dismissal of a case against a man who was accused in a child rape, which we wrote about. What are some of the results of this? The The sheriff's office now has an ACIC terminal, which is probably the most important thing that came out of this. These warrants are now being entered. We do check on that. The Arkansas Supreme Court also ordered an audit of that county's court system, and that generally confirmed our findings. They basically did the same thing we did. They went through all the court records, and they listed out, what basically the disposition of those cases were. A special judge was assigned to that district and still is. The county has cut its case backload in half since then, because that was another thing that we also found, was that when you're not serving these warrants, that's why all these cases stack up. And so you would have people that would have 5 or 6 pending cases that in some cases were 15 years old. But now that backlog mostly has been cleared, but a federal investigation is still ongoing in the region. So, questions?
You said months. How many months did it take to develop it and report this story?
We started in October of 2011. We were continually reporting, and actually we published some of our findings in May of that year, some of the earlier findings, but then we actually continued that. It took probably about 12 to 14 months, overall, and actually we still do some work. We're still working on some things down there.
What caused you to worry about the situation? I don't know if you mentioned that.
There were some sources.
What's gone unanswered?
Can you be a little bit more specific?
What are you still seeking?
Yeah, I can't tell you that. But I can tell you a few things that are unanswered. I would say that I've said that there are these results. As with any government organization, you always need to be checking back to make sure that stuff is still going on, because this is a bad situation, and I think that the general agreement there it was, and that's kind of have to be objective about it. I'm not trying to have an opinion about it, but I think you could say this was a bad situation. There are bad situations that happen in government, and once they're corrected, you need to also then check up to make sure that they're still trying to work to fix some of those things. I would say that that obviously there's still a federal investigation going on, so there's some questions there as well. And I will say that Arkansas State Police also and the FBI, they launched this first investigation that netted all of these people. It was a long investigation. It took 5 years. And, we wouldn't have known. We wouldn't have even known to go in and look at this if they hadn't been, investigating this area and doing the work that they were. So, I say this is what we found. Well, they started looking into this before we did.
How far back did the information go that you were able to access?
Court records, we had access all the way back to 1989. We actually stopped at 96 because we looked at the fugitive book, which is just a big book about this tall. It was. Now I think it's shorter. But the book basically went back, and the oldest warrant in there was 96. So we started at 96 and went through. And, I say we looked at every case file. There were a few that we missed. There were. So, and there were some where we would have, it was iffy. We had a block of defendants, and then we would have maybe another 30 or 40 that we said, well, we don't have it nailed solid. You got to have it to publish it. So.
I'm curious, Chad, as a tax-paying citizen who is concerned about the democracy that holds its officials accountable, and I say that as a people person.
Yeah. This is a tough question, isn't it? I'm ready.
I'm curious how much time you were allowed. I know you said 6 to 7 hours a day, which seems like an extraordinary amount of leeway for your newspapers to give you, and I commend them for that.
Mhm.
But I'm worried that is being short-circuited and will not continue as much as we see.
Are you worried that newspapers are not dedicating more time to people that can do that? I would agree. I think we should do it more. My boss is sitting behind you. His name's Danny Shamir. You can talk to him. Okay. But
Again, as a citizen, not as a PR person, because I just think you guys leave us alone, because we're good. We're all
and we will annoy you like crazy. Believe me. But yeah, I see what you're saying. Yeah, we were in a special circumstance where we were able to, we had discussions with our bosses a number of times when they said, when are you going to have this done? And we just pushed back as hard as we could. to say we're not there yet. You know, you have to have it. You have to have the documentation to be able to say this kind of thing. And, you know, we go through a process of fact checking. There were things where we would say that this is not there. It's just not there yet. We got to go back. And, you know, we were given that leeway to do that. So hopefully we will continue to have that. And other reporters who are also in the room will have, you know, the ability to do that.
When you were given access
Yeah.
to all those blocks of records in that, you know, whatever, you were locked in that cell.
We're locked in the cell. We were locked in the area. So, yeah, we were free to move about with the inmates. Yeah. So.
The information you had to have been looking at probably had confidential private information, personal information that might should have been redacted by a custodian.
You know, that's a good point. And I'll tell you this, that I'll tell you this, we actually never, it was an adult jail. There was never any juvenile information that we came across. And honestly, if we'd come across juvenile information in that jail, we would have written a story immediately, because that's a problem. But right. Actually, none of those came from the jail booking records. All of those came from public court records. And so in those cases, you know, basically what we were able to see is actually the affidavits of that information, and those are redacted with juvenile information in them. Sometimes you're right, though. We will come across confidential information that just gets mixed in. We don't publish that kind of information. We don't care about Social Security numbers. We don't care about all that other information. And that's, you know, that's just not what we do. We have to be responsible about that. So, but you're right. Yeah, sometimes, you know, it was their call. Is that good? All right. Thanks.